Dear students, today we are going to learn about the nuisance as a tort. Nuisance actually means annoyance or to do hurt. This is derived from the French word nuire, N-U-I-R-E, which means also to do hurt or to annoy. The word nuisance had diverse and exhaustive meanings. There is no specific meaning of it. In the case of Durga Prasad versus State, it was observed that nuisance means anything which annoys, hurts, or that which is offensive. In fact, nuisance as a tort means an unlawful interference with a person's use or enjoyment of land or some right over or in connection with it. This was the definition which was given by Winfield, but this definition seems to be incomplete. If we look at the definition of Pollock, that is more appropriate. Pollock defines nuisance as a wrong done to a man by unlawful disturbing him in the enjoyment of his property, not only land, or in some cases exercise of a common right. So here we have got a wider connotation, wider meaning of nuisance. Nuisance actually is interfering with the comfort, health, or safety, which are the examples of it. So in the next, nuisance as a tort has following essentials. The first one is a continuity, means the annoyance must be in the continuing order. State of affairs must be in constant. And however, there was a case of Dolman versus Hillman that in which the defendant was held liable even for an isolated act when the plaintiff slipped on a piece of fat lying on the defendant's butcher shop. This was a case of nuisance and negligence. Nuisance is of two kinds. Number one, public or common nuisance, which is also a crime under section 268 of IPC. Another one is the private nuisance, which is a tort or a civil wrong. So let's continue with the essentials. First one which we have discussed is continuity, and in which there was a case Dolman versus Hillman, in which there was an isolated case of it was an isolated act. Even the plaintiff demanded the redressal for his slipping on a piece of the fat lying on the defendant's butcher shop. So in this case, the court held that the defendant was liable to pay the compensation to the injured party. Now let's continue with the essential. Now the second one is the unreasonable interference. Whenever there is an interference caused by the defendant to the plaintiff's property, or anything which is caused as a physical or personal discomfort to the plaintiff in the enjoyment of his property, every interference is considered to be a nuisance, provided that is having a continuity. If it is not continuous, then it is not a interference. Second one is interference with the use of or enjoyment of land. Interference may cause either injury to the property itself, by example, by allowing the branches of a tree to overhang on the land of another person, or to escape of the roots of a tree, water, gas, smoke, or fumes, etc., on the neighbor's land, or even by vibrations, or injury to comfort or health of the occupants of certain property. For example, excessive noise being emitted by a mill in a residential area is also a nuisance. Another very landmark case is Nobel versus Harrison, in which the court held that the branch of a tree which was overhanging on the highway, because of the plantation of the tree by the defendant, the court held that defendant is not liable since he planted the tree for the greenery and the greenery of the area. There are two more landmark cases, Dr. Ram Rai Singh versus Babulal, and another is Campbell versus Paddington Corporation. In the first case, Dr. Ram Raj Singh versus Babulal, AIR 1982, the defendant erected a brick grinding machine adjoining the premises of the plaintiff, who was a doctor. The dust generated by the machine entered the plaintiff's chamber and caused physical inconvenience to him and his patients. As a result, it was held that special damage to the plaintiff had been proved, so the plaintiff was given the redressal by the court. Another case is the Campbell versus Paddington. In this, there was the defendant was no other but the municipal corporation, and municipal corporation here constructed a stand on the highway in front of the plaintiff's building, which obstructed the view of the funeral, which was of no other but the King Edward VIII. And everybody was very much eager to see that funeral, and the plaintiff entered into the contract with many of the persons for having the view of the funeral through his window, but that plaintiff could not succeed in his objective, reason being the municipal corporation there erected uh, boarding hoarding on the way in front of the plaintiff's building, which obstructed the view. In this, the plaintiff thus was deprived of the profitable contract of letting seats in her building. She filed a suit against the corporation contending this stand was a public nuisance and had caused special loss to her. So the court held that she was entitled to claim compensation. So here we have got